Very much. You can be seated. Mr. Tessier, I believe it's your opportunity to cross-examine the witness. You may proceed.
Thank you. Mr. Preston, I'd like to talk to you about Mr. Thompson's employment with the county first. You spent some time on your direct exam discussing Mr. Thompson's hiring by you into a buyer two position. Do you recall that?
Yes, I do.
And I know you spent some time explaining that the hiring of Mr. Thompson could be classified as a transfer rather than a new hire.
Yes,
Is that your testimony?
Yes.
It doesn't matter in terms of whether it's a transfer or not. I think you agree that you can still hire anyone to a position regardless of whether you're looking at some folks as a possible transfer into that position. Do you agree with that?
Yes.
So in other words, you could have opened up the buyer two position to anyone and not just held it in reserve for someone who might transfer to that place.
Yes.
You also agree with me, do you not, that you had to make an affirmative decision to hire Mr. Thompson at some point, right?
Yes.
And in fact, the last step before Mr. Thompson was officially hired by Anderson County required you to sign a personal action form on his behalf, right?
Yes.
And that did not happen until after November 18, 2008, correct?
Correct.
You talked a lot about, with Mr. Davis, you talked a lot about the percentage of applicants who had MBAs, the percentage of applicants who had the type of educational background that Mr. Thompson had, and perhaps the percentage of applicants who had military service. What I would like to know is, what percentage of applicants to that buyer two position that came open in November 2008 had just voted to give you a $1.1 million severance agreement that would allow you to retire at age 45?
Only one?
And that was Mr. Thompson, right?
Right.
You also agree, do you not, that Mr. Thompson needed that job, didn't he?
Yes.
He needed the help benefits, didn't he?
That's what he said.
So he had a pretty strong incentive to ensure that he got that job, did he not?
He started asking for it back in February, March.
He never let up, did he?
Yes.
You were talking a little bit about the classwork that Mr. Thompson was able to take, those auditing, or I'm sorry, those appraisal courses. You agree, do you not, when you heard the testimony, Mr. Thompson said that those appraisal courses had no value to him as a county council member.
That's what he said at the time.
You happen to disagree with that.
No. Yes, sir. I'm going to ask you not to ask witnesses to compare their testimony to other witnesses.
Did you send...
Each witness testifies on his own.
Yes, sir.
Thank you.
You said, if I heard you right, that you thought this was valuable training for any county council member, correct?
Correct.
Did you send any other county council member, or let me ask it this way, are you aware of any other county council member in 2008 who went to appraisal courses besides Mr. Thompson?
Not in 2008.
Would you agree with me that taking the appraisal classes is not a foundational course that every county council member takes once they come into office?
Not those particular classes, but the Association of Counties, they do offer some
They offer some classes.
that relate to the subject matter.
And do you pay to train everyone who is going to come into the purchasing department to get appraisal courses?
My policy as county administrators, if the county employee was interested in taking any kind of training or trying to improve themselves, if there was money in the budget for that, I would more than likely approve it, providing if they asked me.
And with respect to the benefits of Mr. Thompson personally for taking appraisal courses, do you agree that taking those appraisal courses did put him in a better position with respect to an application for a job in the assessor's office than if he did not have them, right?
He could have.
And same with the purchasing department. It puts him in a little bit better position than if he did not have them before he goes into the purchasing department, right?
He could have.
The average Joe out there in the community, if they want to get a job in purchasing or if they want to get a job in the assessor's office, they have to pay their own way to get the type of qualifications they think they need to be a strong candidate for the position.
Not necessarily.
They all pay their own way.
Not necessarily.
How does the county offer free training to the average Joe who's applying for positions with the county before they're ever hired?
At times,
They do.
well, if, for example, if someone applies for a job in the assessor's office, for an assessing position, I'm not sure exactly at that time, usually it's up to the administrator as to whether or not those classes will be paid for or not by the county.
And that only happens after they're hired, right?
After they're hired? Yes.
You don't make training available on the county dime to applicants for positions, do you?
No. But if they currently work for the county, we do.
I understand. Your severance agreement discussion, you talked about the covenant not to sue and your position with respect to that covenant. Can you show me any language in the severance agreement that amounts to an incontestability clause?
No,
Do you know what an incontestability clause is?
not exactly.
Can you show me any language in the severance agreement that says that the validity of the agreement itself cannot be challenged by either party?
No.
Back in September 2008, when you made your claim against the county, which was about September 25th was when the lawyer sent the letter, is that right?
Yes.
And then the vote on the severance agreement was November 18th, 2008, right?
Yes.
During that period of time, which is almost 2 months of time, would you agree with me that the severance agreement discussion and the possibility that you might get a severance agreement from Anderson County was perhaps the single most important event going on in your life at that time?
I was going through a divorce too, so I don't know.
In that time frame, September to November of 08?
I was going through this.
That'd be another big event, right? Would you agree with me at least that the possibility of getting a severance agreement from Anderson County would be one of the two biggest events going on in your life at the time?
Yes.
And that's the kind of thing most people talk to other people about, right? Big events going on in their lives.
Yes.
They usually find somebody to confide in about those kinds of things.
Depends on the person, I guess.
And your testimony to this court is that you didn't talk to a single person about the severance agreement coming down the pipe, except for the one conversation you had with Mr. Thompson. Is that right?
I don't know. I don't recall any conversations I was having with anyone about it.
Would you agree that your testimony is that you had no conversations with Ms. Nichols about whether or not you had sufficient votes for your severance agreement?
Like I said earlier, I don't recall having any conversation with her about whether or not I had sufficient votes.
So then you don't deny that you could have had such conversations.
I don't deny that.
You just don't recall.
I don't recall.
And the same with Mr. Greer. Do you recall having multiple conversations with Mr. Greer about the severance agreement?
No.
Do you deny that you had such conversations?
Yes, I don't recall having multiple conversations with Mr. Greer.
Do you recall having conversations with Mr. Cunningham about the terms of his contract that was going to be voted on to replace you?
When I was listening to Michael testify the other day, I remembered him emailing me a copy of a contract that he had. I remember looking at that. I didn't recall that at the time I gave my deposition.
So you would agree now at least that you had some communication with Mr. Cunningham about the possibility of his having a contract to replace you as administrator, right?
Yes, either, I don't recall if it was before or after. Mr. Cunningham and his situation was not that important to me at that time.
And you talked a bit about how difficult this case has been, some of the discovery battles that you've had in this case, and I guess trying to demonstrate why it's been pretty expensive in terms of litigation. You remember that?
I remember that.
You remember telling Ms. Nichols to keep her mouth shut in hope that she would not testify at a deposition in this case?
It never happened.
Never happened.
No.
You recall that you asked her to cover up your affair with her.
No, I never did that.
And you recall that you concocted a story with Deputy Chief Boucher to mislead County Council about having a catered lake.
That's a lie.
This is exceeding the scope of your act.
This only goes to the credibility question, Your Honor. I'm almost done with it. That's all. I'm not asking.
We don't go by the length of your examination, it's what you're examining the rule on. You want to speak to that?
Yes, sir. I think credibility obviously is in question, since among other things, Your Honor, he's testified on direct, so his credibility is already in question, and he's testified about his financial position because he says he doesn't have the ability to pay. And so it's important for the court to evaluate his credibility. That's why it's relevant.
Your Honor,
it exceeds the scope of direct, and I'll also point out that during their case in chief, they put in the deposition designations of Mr. Preston, and they captured the same testimony they're replowing now. This is cumulative.
Your first ground, I would overrule his right to inquire on questions of credibility. However, Ms. Tessier, I believe this information has already been discussed in the depositions, the portions that I've seen.
And I don't dispute that, Your Honor. I'm not going to ask any more questions about it.
Let's not plow the same ground twice. I agree that could be cumulative. Is there something new on this subject?
Well,
I'd be happy to hear it, but I don't recall anything new yet.
This would be the new area, Your Honor. You talked about not being able to repay the money that was paid to you by Anderson County. Do you remember that?
I do.
You agree with me that you are currently drawing $7,688.07 a month in retirement from the South Carolina retirement system?
I am.
And that figure will only increase over time, will it not?
Very little.
But it will increase. It won't decrease.
Very little.
It won't decrease, right?
No, it will not. Depends on what the General Assembly does, how they manage the program.
So you never earned more than about $160,000 per year in salary in your career, right? In salary.
That plus any other income I may have had.
And you're now drawing about $7,688 a month just to go to the mailbox, right?
Yes,
And that equates to about $92,000 a year.
that's right.
You don't dispute Dr. Alford's testimony about the value of your retirement payments, do you?
Yeah. I would object. I mean, they've asserted claims in this case for rescission. If this contract is undone, all of this line of questioning that he's asking him about, there won't be the benefit he's cross-examining him about. He's asking a lay witness things that require legal conclusion, and he knows full well they have a claim for rescission, which if the retirement system gives back their contribution, that flow of income stream that he keeps badgering him about won't exist. This is unfair.
I'm aware of the relief that's being sought, and he's on cross-examination. I'll give you some latitude. But the claim is to rescind the contract.
That is correct, Your Honor, but one other option the court has, since it's a court of equity, is a partial rescission. So the court could decide.
There's multiple things the court can do in equity, but
Yes, sir, and that's all. I mean, that's our point.
legal claim that you made is for rescission of the contract.
That's correct, yes, sir.
All right.
You don't dispute and can't dispute Dr. Alford's testimony about the value of the retirement payments to you, do you?
I can't, I'm not qualified to speak.
In other words, you would agree then that the value, the present value of the retirement benefits you are going to receive as a result of this severance package as compared to the value of the severance, the value of the retirement you would have received had you not had the severance agreement is close to $1 million.
That's what he said.
You recently landed a job as county administrator for Bamberg County, correct?
Yes.
And in fact, you structured that deal so that the contract between Bamberg County and
Your Honor,
York.
relevant?
Sustained. What's good to the goose is good to the gander. I don't go to Bamberg.
Well,
I'm preventing him from going into it. I'm not going to allow you to do it.
well, I think the difference, Your Honor, I certainly
Well,
will.
stop. Go ahead and tell me the difference.
The difference being that they were trying to talk about conversations between Bamberg County employees and Anderson County employees. I'm just trying to show you that he has another income stream available to him now,
And what's that got to do with this case?
with which he's the one who claims he can't repay the value when he got.
Has he taken that job yet? I understood that he has not yet.
He's under
Has he taken
contract.
that job at this point?
He has been offered the position and they've executed a contract, but they haven't started work.
Okay.
I think he's going to start next week, or it might have been this week, actually. I don't have any questions. I don't have to ask him if you want to.
We keep garnished wages in this state.
I understand.
Last time I checked, we couldn't.
I understand that. But I won't ask the question.
Let's move on.
Mr. Preston, you invested about $200,000 with Ron Wilson's Atlantic Bullion Company, correct?
I did.
And you made that investment in two pieces. $150,000 or so in the first quarter of 2009, right?
Yes.
$50,000 or so in the second quarter of 2009, right?
Yes.
So these are the first two quarters financial quarters after you got the severance deal from Anderson County that Ron Wilson voted on, right?
Yes.
And most of the investments that you made came from the funds you received in the severance deal, right?
That's some personal investment, personal savings in that too.
Most of it was the severance one, correct? And you sent a number of investors to put their money with Ron Wilson's company, right?
No,
You sent some investors.
I didn't send anyone.
Well, how would you characterize what you did with respect to investors in that line of work?
I just referred people to them, friends,
So you referred them, you didn't send them. you
in
referred.
discussions with them about my investment.
And that was multiple investors, right?
Yeah.
More than one.
One more.
And you got paid by Atlantic Bullion when you referred people to Atlantic Bullion who made investments, right?
I wouldn't categorize it as being paid.
You received a credit to your investment account, did you not?
He put on paper a referral fee that I never did see or experience.
Now, the $200,000 you invested, you agree with me that you drew out checks from the Atlantic Bullion account you had of at least $600,000 over the course of the next couple of years, right?
We don't know that for sure. We don't have clear on that.
You called your testimony in your deposition about how much you took out?
Yes, I do.
Do you dispute that you said it was about $600,000 over that period of
I
time?
recall too, there were problems too with the accounting on the statements too. We don't know for sure exactly.
Okay, I'm gonna have to play your testimony now, I believe. You received, when you drew this money out, correct me if I'm wrong, you actually drew out hard checks, correct?
I pulled from my own investment account, yes, sir.
And that was, they were hard checks written by Atlantic Bullion, right?
Correct.
To you.
Yes,
$50,000 sometimes,
yes.
$75,000 other times.
I remember one.
And your recollection was that the total of those amounts that you drew out of that account was about $600,000, right?
We think it might be, but we're not absolutely sure yet. We're trying to reconcile and find out.
You're the one that took the money out, right?
Yes, sir.
You're the one that signed the checks, right?
Yes.
And then you presumably deposited it in some other account,
No, just in my checking account.
which is another account, isn't it?
Yeah.
So you signed, endorsed the check, put it in your checking account.
Yes.
And you don't recall if it was $600,000 or not.
I don't recall it right now. My accountant's trying to figure it out.
Would you agree with me that you still had money left in your Atlantic Bullion account even after you took out the $600,000 or so?
On paper.
You list on your personal financial statement several pieces of real property, right?
Yes.
The one that includes your home also includes buildings that you use for your business, Hammond Preston House LLC?
Yes.
And the fair market value of that property is listed at $600,000?
Yes.
You also own a timeshare worth $30,000, according to your statement, right?
Yes.
And you have a 1/5 interest in a house in Charleston, which is valued at, the house in Charleston is valued at $376,000, right?
Right.
But you have a 1/5 interest.
Correct.
And you also own some real property in King, North Carolina.
Correct.
You were able to, according to your financial statement, you were able to rack up over $250,000 in American Express charges.
Yes.
Presumably, you had to give them some kind of indication of your financial position in order to get an account that would allow you that kind of leeway, right?
It's an old account from 20 years ago.
Would you agree with me, Mr. Preston, that plaintiff's exhibit number 91, which is the personal financial statement you gave, that is not an audited financial statement of your net worth, right?
Right.
We have to take your word for it, don't we?
My accountant would endorse and say it's true.
Is your accountant here to testify?
No, it's not.
If you look now at your damages, I'm going to show you exhibit number 37. That's, I think, your attorney's fee arrangement with Nelson Owens. It's probably on your desk. In that notebook. Defense exhibit 37.
37.
37, I'm sorry. You agree that that's the fee arrangement you have in Nelson Owens for this case?
Yes.
And it indicated you were supposed to pay $150,000 plus a contingency element, right?
Right.
And of the $150,000, you have not paid all of that yet, have you?
No.
In fact, you paid about $115,000 of that.
Correct.
Do you have any documentation that will show us what the $115,000, how it breaks down in terms of what legal work was done on your behalf in exchange for that?
Yes. I don't have it with me.
You didn't bring that with you? What about upstate law group the deal with state law group is to pay them an hourly rate of $220 an hour.
Correct.
Is that, is your understanding that that was the full hourly rate that you would normally pay those state law group for the representation?
I believe so.
In fact, you had them represent you in other matters for the same rate.